And so one example of such an instance where a reexam actually was denied is the Vivint case that people may be familiar with. I'll spare going through all of the facts in detail, but essentially someone had tried to file multiple petitions that were denied for various reasons. And then they decided to file a reexam, which was granted. And there ultimately was a final office action issued rejecting the claims. The patent owner appealed, arguing that the 325D or that 325D should apply here and that the reexam should not have been granted. And there the Federal Circuit did agree. So again, this is sort of an outlier and a pretty extreme case to show you what links someone would have to go to for a reexam to be denied. But just wanted to, you guys can look over the slides and, didn't know if the panelists had any thoughts in particular on the Vivint case, and if that's changed, whether, for example, you try to address these issues preemptively in your request, if you're in this kind of factual scenario, or anything that changes in how you develop your reexams.
So with respect to 325D, I think that the office has not quite come up with a way to address it yet, because I've filed petitions for 325D where there were parallel IPRs that had been denied. And they tell you that you have to do it beforehand. They tell you that you have to do it after because they can't do anything beforehand. So it's up in the air. I've actually had a couple granted for the reexams to be under Vivint. So they have taken away the reexam, terminated it, but it's very up in the air right now, like what the process is, how you're supposed to approach it, where, who decides the 325D petition. This is an area that as we were speaking of earlier, it's just much cleaner if you start off with a reexam, because once you've failed in an IPR, there's all these boundaries that you have to cross in order to be able to get into the reexam process, or just, get yourself out of the situation that you're in. But the 325D can become, and I think will become, a very big hurdle in the reexams, because you can't be saying that 325D is effective in an IPR and the same statute is not as effective with a reexam. So in the end, I think the patent office will do the right thing and say, you picked your forum, you picked an IPR instead of a reexam, and you're coming here with either the same art or similar art, and no, you shouldn't be able to do that. But if you pick the reexam to boot from the get-go, then you shouldn't have any of these issues. But you do have to put your arguments in right from the get-go and try to put them to the patent. If you're going to put them in as a requester, you should have to, if you have 325D arguments, put them in.